because they never should have been arrested in the first place. The judge also acknowledged that if the Customs and Border Patrol and ICE had merely followed federal law and our consent decree, there would be nothing for him to order. There would be nothing for him to interpret. But his view of our agreement is that folks who do not have criminal histories or of risk of danger to the community, who were unlawfully arrested without probable cause, should be released and should not be mandatory detained.
The one thing I was going to add is we have already started the process of identifying violations. They have produced 110 full arrest files to us. We have alleged that 65 of those 110 are violations, and they've agreed with us in 70% of those cases. And the others are all the same dispute that once we have an order from the judge would mean, if we are right, that 65 out of 65 of the people we allege were violations that the government is forced to agree with based on the court's order. So these aren't speculative that these may be violations. As things play out, we are finding that disproportionately these are all violations. And of the remainder from the 110 to 65, the vast majority of those people had prior orders of removal. We've never argued that those individuals are class members. So once you take those out, what we are seeing is that disproportionately the people that we are raising as violations, in fact, the government is having to concede that yes, they have been consistently violating the consent decree.
And I'm sorry, because this is very confusing. Are these 100 and so folks part of the 615 pool or separate?
They are part of the 615 pool. So but that 110 is as to the final decision. Is this a violation or not, and should they be released? The 615 is because the government has been unlawfully detaining people in mandatory detention, which he addressed and said is unlawful, and hundreds of courts around the country have agreed with his interpretation of the law. Because of that unlawful detention, people are giving up. And so in the interim, he is ordering, as to those 615, who are all potential class members, that they be put on an alternative to detention until we can get that adjudication like the 65 that I just mentioned.
Now, realistically speaking, how many of those 615 do you think are still in the country and they've not already voluntarily self-reported?
We don't know, but based on what we've seen from what they've produced, I'm very fearful that at least a couple hundred of them are already gone, because that number comes from October 22nd. It's been a couple weeks since then.
Did you say when they were arrested, the time frame is 615, how long they've been in detention?
I believe the majority are I believe the majority are from September and October. There may be some that were earlier arrests if they're still detained, but most September and October.
And so the judge at the end agreed, am I correct, to ask the DOJ to identify of all who've been arrested, the 3,000, so how many may fall under the same situation? Can you clarify?
Yes, so the 615 is a subset of a subset. That is just the people who ICE arrested, which was around 1,800 before October 7th. It's just the people who are held under lawful mandatory detention, 1226, and not the people who are held unlawfully under mandatory detention, as the judge held today. So we asked that number, that same assessment also be applied to everyone who was arrested by both ICE and CBP up through the present. And the judge has ordered the government to assess what that number would be, because at the present we only have the 615 that were arrested by ICE.
Do we get the names of the 615 by this Friday and then just the numbers by next Friday?
Yeah, could you clarify the timeline?
Yes, the 615 by this Friday. By next Friday, that broader list. So again, as my colleague was mentioning, that 615 is from a very preliminary number of arrests prior to October 7 and only by ICE. Since then, they've now produced the list that includes all of the Border Patrol arrests, which is at 3,368. Of those arrests are still prior to October 7th. So we don't have any of the numbers post October 7th. So we have 3,368 prior to October 7th as to both ICE and Border Patrol. We are now going to get, by next Friday, that supplemented even further to get us up to the present, up to today. So we will then get also the October 7 to the present numbers. And as part of that, the analysis of who falls into this more like the 615. They're not subject to mandatory detention because of criminal convictions. They don't have a final order of removal, and they've been already deemed by ICE to be a low public safety risk. That's the additional number.
I actually was confused about something, because
Okay.
the judge said we are granting this as to the 615 people. The DOJ came out and said, actually, there are at least 12 on those lists that are high risk. The judge said, well, I probably don't want to release those. So we don't know, like, what exactly is the scope of this order right now? How many people might actually be released under this order and when?
Because Mr. Weiland had asked for another week, and I think that's why we allowed it.
And Mark, just to connect, sorry to pile on, but we heard the number 18 were arrested by ICE prior to October 7th. So where did 615 come from out of the 18?
Let's do it in reverse.
Yes.
The 615 are the individuals who are still here in the United States of that 1,852, that pre-October 7 ICE number.
That we think are still in the States.
Correct. Who are also not subject to mandatory detention under the criminal conviction, or because of criminal convictions. The remaining 1,100 have left, most likely. We don't know for sure in every case, but of those, and that's the urgency here, that's 60% of those people have already given up. Now, with respect to the 615, they have produced a list to us that includes only 400, the risk assessment as to 403 of those 615. Of those, on their own list, it's listed that 313 are designated low. Of the remainder, so whatever, 403 minus 313 of those, they are listed as high or medium. And we will be meeting and conferring with them because we have no idea what medium and high means. They have not produced anything as to what that criteria is. And frankly, the assessment that they do is given a lot of discretion to the officers. So we are concerned that of those like 90 or so, that in fact, once we dig below the surface, that the high really doesn't represent anything, or the medium doesn't represent anything.
There's no government designation that's been used for years that there's a common understanding of high and medium risk. There's no like rubric. It's just very subjective, you're saying?
So they've used two different rubrics. We asked for one that is crystal clear. They have refused at every turn to give that one because they don't like what the numbers show. The rubric we asked for that they apply to people in detention shows that 85% of people have no criminal convictions who are in detention. They don't want that rubric, and the judge seems to allow them this leeway. As to the risk classification that we're talking about, the high, medium, and low, we don't really know what the high and the medium is. We believe that the high is people who have been convicted of what are referred to as aggravated felonies and would be subject to 1226C anyway, so we're a little confused by that. But we don't know what the rubric and what each of those exactly mean, unless you have...
But at least just to fill it clear, like even by their count, their overwhelming majority are still not high risk.
Correct. That's the through line. The through line is so they said 615 potentially still here, not subject to mandatory detention. They were able to give us their risk assessment for 403. For whatever reason, they can't work out the computers to give us the other ones. Of those 403, 313 are low. So yes, the through line is disproportionately the people that fall within this are low risk and thus should be released.
Then 12 are high risk according to them, and then the rest are medium?
Yeah.
And the release of the 615, that was stayed for a week, right?
Friday, right?
Like he
Yes.
initially said Friday, and then he stayed it for a week, right?
As to the ultimate release, correct.
And of course, these people are all over the country at this point.
Yes.
They are held all over the country. And that's where the logistics of when we, at the end, my colleague was asking, like, how is this bond? How are they going to be notified? The logistics of where these people are is going to be a piece we really need to work through with the government, because we want this to be realized.
So it's across the country.
At this point, they are being held across the country, correct?
The arrests are from.
But all the arrests happen here in the Chicago area.
I'm so sorry. So the potential releases are stayed until when? Is it this upcoming Friday or next Friday?
So for the 13 people that were for the 13 people that were discussed at the beginning, we're hopeful that they will be released immediately, as quickly as in the next day or two. For the remainder, I think that it will be stayed for a period of time.
Can you identify what those 13 people are?
The 13 people that were identified that were at the beginning of the hearing, those are people that we identified as violations. The government agreed with us that they are violations. There's no remaining outstanding dispute as to those individuals, so they should be fully released without any placement on alternatives to detention.
Violations of custody and
Yes.
No.
They're separate from the 615.
So they get released immediately. The next one's in a week, and then information by
And
Friday.
then they're supposed to provide us with a list that will be in the thousands that breaks out people like in the 615, and so that next tranche should be a lot larger, provided they don't appeal or whatever they seem to be wanting, hence why he was suggesting about the stay.
Just speak about the impact that this could ultimately have. You know, once we get this complete number.
I mean, I think it will show that this whole operation, for the last 2 months, the terrorizing of our neighborhoods, the brutalizing of people here, has all been unlawful. That's what it's going to show. It's going to show that all of this, all of the tactics of Mr. Bavino, all of the tactics of ICE have been unlawful in the vast, vast majority of arrests. That's what it's going to show. And so if they plan to come back, they now will have to abide by these court orders going forward, and they cannot do their enforcement in this way.
Sorry to jump in. Can I just ask, just really quickly, I know that there, correct me if I'm wrong, there are stays of removal of military departure on the 615 until next Friday, is my understanding. Is it Friday or Wednesday? Or the 21st, I don't know which one it is. But the other people that the judge has asked this the 3,300 or more up until today's date, do you think there may be moves made in the interim to get those people out of the country, to remove them, people that are not covered under the stay?
I mean, I think yes. I think that is a real risk, and part of the reason why we have advocated for so much urgency to all of this is because with every passing day, more people are being coerced into giving up their rights. They're taking voluntary departure without being informed of whether or not they even have a right to a legal remedy in this country. And so I think that's why, from our perspective, the time is of the essence, and that's why we have to just do nothing but keep pushing the judge and the government to act with speed.
I'm sorry for this timeline clarification one more time. By immediately, hopefully the 13 people would be released and aren't on alternatives at all. Then the 615 would be released by when? Wednesday of next week?
Portion of
Friday,
the
615.
And when is it going to be determined what portion of those 615 actually is going to be released by the judge?
So the 615 are going to be released under this alternative to detention, right? The 615 are going to be released under this alternative to detention, and that gives us the time to figure out if they can be permanently released under the consent decree.
But by when?
The time frame, I think, is that we have a week.
So the judges ordered them to present by this Friday the people that they are claiming cannot be released of those. And as I said, of the 403 that they've given us, 313 are, by their own metric, which is a flawed metric, low. So we would anticipate that those people would be eligible for release. My understanding from the judge's order is that next step of releasing them is stayed until next Friday, pending apparently talking to other people in DOJ exactly how they want to proceed.
Now,
So you're
because we're
expecting
talking
at
that
least
they're going to
300
be
to be
released.
released on 18 by next Friday.
Go.
Could you just
Yeah.
start from the beginning, not like this one? Like say, I'm the 13 and these days, or 100 blah blah blah, just because you keep going back and forth with the numbers and that's.
Do we have it listed out someplace?
So 13 released by this Friday. By this Friday, they need to present to us who they are claiming is a public safety risk of the 615. They identified apparently 12 today that they think, but they had no justification. Okay? That's by Friday. That then is supposed to set in motion them to be released, right? He has said, I'm going to stay that at your request, the process of release, for a week till the following Friday. Separate from that is, of course, the people that weren't on that original list. So all the people that have been arrested since October 7th, for example, they are to produce to us a list comparable to what they did with the 615 as to all of those arrests up to the present. And I believe that was by November 21st. So.
And just to clarify, the
19th, November 19th.
To clarify, the folks that are going to be released on Friday, these are the people that there's no dispute, they're not being released on any sort of conditions, they're just being released. And then whoever remains in the 615, these are people that are going to be released on bond. So there is a condition attached to their release.
That's correct. Yep.
Now and we're on Friday.
By Friday.
Now, for the people who you said will be released to alternative detention, do you mean they'll be taken to a local jail?
No. Alternatives to detention is a term of art that ICE uses for people that are placed on bond, placed on an ankle monitor, placed on what's called SmartLink, which is like a photo, like an app.
So several of these people could end up with an ankle monitor while their case proceeds.
Yeah, go ahead.
So it's a really important question that you're asking, because what the judge said was they're releasing them for purposes of us to negotiate about them. And if in fact they were full violations, and we can fully agree to that they were full violations, then their bond money should be returned, and the whatever the condition of release would be taken away.
Do we basically have to have bond hearings for each of these, however many folks are left, or it's just a blanket?
He has ordered across the board that they all be released on a $1,500 bond, which is the statutory minimum. So there's nothing to, the law says that is the minimum that the minimum bond by which somebody can be released from custody pending their case. And so he has short-circuited that need to do that.
I have two more numbers questions that I swear to God were not repeats. Number one, a few weeks ago when we were last in front of the judge, you guys said you estimated that of the 3,000 or so that we knew of, that number is that number's old now, but of those 3,000, you thought that 2,000 would probably ultimately be eligible for alternatives to detention. Do you feel like you're tracking that 2,000, or maybe even you might be above that?
I suspect we will ultimately be above that, and also realize that they've already now produced to us that before October 7, there were 3,368 arrests. And so I think as far as a percentage of the people, absolutely. And I think the other thing to point out is once we see the files, disproportionately all of these are violations, and the government is being forced to agree with us that they're violations.
And then number two, I expected to hear an updated arrest number from both Border Patrol and ICE here, but we didn't have that. You guys had some sort of internal estimate, or why didn't they go to 81?
They claim they were only ordered to produce up till October 7th.
I thought we were also supposed to get them on our rolling.
This will be further discussed.
Are you concerned that people have fallen through the cracks and you won't know where they are?
are their records comprehensive enough that you can track everybody?
No, I think the absolute reality is that we can only track them with the information that we have, whether it's through family contacts or through that ICE locator. Yes, there will be people who fall through the cracks. There will be people that give up and voluntarily depart, and we can only move as fast as we can to identify people for the court and use the information that defendants provide us.
You said that number's up until October 7th, but from when is that number?
June 11th, or June 12th is basically from June 12th to October 7th.
When you get the information on these other detainees, will that just be numbers or will it be names in their case files?
It will be their names, their A numbers, their country of origin, their arrest date, but then also what was their classification as far as their risk assessment. So like, were they low, medium, and high? That's the initial part. But the reason we're trying to get that is so that we can get people out while we adjudicate the individual violations. From there, we will get then the arrest records for all of those individuals over time. But, given just the enormity of the violations here, they're just struggling to even produce those records to us in any timely way.
Sorry, my name's Winnie, I'm from CNN. Big picture, nationwide, in what way do you think that this case will be a framework for other organizations across the country to bring similar complaints? Because it's specifically about a consent decree here and not, about like a general constitutional question, or maybe it is and I'm misunderstanding.
Well, there are already similar cases brought by the ACLU in California and in other states that model the case of Castellano, right? We are dealing with Fourth Amendment violations, unlawful arrests of people without probable cause, and we're dealing with people who are federal officers are arresting people without even following the federal immigration law. And so there are already ongoing lawsuits that model the one brought by the National Immigrant Justice Center in the ACLU of Illinois here. So what today's ruling shows is there's a path forward. There's a way for the court to address violations of law in a clear way, whether it is ordering release or ordering that there be an alternative to detention while the notion of the parties working out the violations. There's a path forward. So we are seeing our colleagues in other cities and countries bring similar lawsuits because we know that the Customs and Border Patrol and ICE are doing the exact same thing. They're unlawfully arresting people without probable cause that people here unlawfully or that they're likely to flee. We know that they're engaging in racial profiling. We know that they're targeting even U.S. citizens based on their ethnicity and where they work. So our colleagues at the ACLU are bringing similar lawsuits based a lot on the Castellano case.
That's a novel that applies across the nation.
The Castellano case, the broadcast policy, which prohibits unlawful arrests without probable cause, that applies to ICE and CPB across the country. Our consent decree is limited to the areas of Illinois and 5 states in the Chicagoland area.
So what are the different provisions, nationally versus locally?
The national is that there is a set policy nationwide of when and what they need to do in order to make warrantless arrests and vehicle stops. And so that policy, if violated elsewhere, can form the basis of lawsuits elsewhere and is already, not only in California, but the ACLU of Colorado has brought one. And there are multiple other organizations. Washington, D.C. also has a very similar claim in their lawsuit. And so there are others, and there will be more, because as we heard, in the last couple of days, Border Patrol may be leaving Chicago, at least for the time being, but they're already planning apparently to go to Charlotte and New Orleans. And so this terrorizing of the American public is not going to stop right now. And so we fully intend to support colleagues elsewhere and frankly also probably bring lawsuits elsewhere to enforce the limits of their authority to make warrantless arrests.
For those who are currently detainees in ICE custody, they've already signed off on the self-deportation document. Is there any way
As to people who are still here in the country, yes, there is now a stay from the judge that those cannot be executed. You cannot remove someone on a quote-unquote voluntary departure or a removal order that has happened in the meantime while the process of releases play out. As to folks that are here or who have already accepted voluntary departure and are gone, there's nothing we can do within this lawsuit, and that is the urgency of why we are bringing these motions for temporary relief.
Do you know when the 13th is? What's that?
Today, through, as to the 615, there's the stay of them being released, but alongside that is a stay that they cannot execute on a voluntary departure or a removal order during that same time period, i.e. that they shouldn't be punished for the government's request for a stay of their release. Yes.
Michelle, ¿hablas español?
Sí.
Sí. Básicamente, se puede decir al micrófono, ¿qué pasó el día de hoy? ¿Quiénes van a ser liberados? ¿Qué pasó en lo que dijo el juez?
Okay. El juez Cummings ordenó hoy que 300 personas tienen el derecho para salir de la detención de ICE o Customs and Borders. Es la primera cosa. La segunda cosa es que 15 personas tienen el derecho a salir con una alternativa de detención. Por ejemplo, un braceleto o con un A. Y con estas personas vamos a negociar con el gobierno que estas personas pueden salir permanentemente según de nuestro acuerdo con la Corte.
¿Y la próxima semana qué pasa con la otra lista de personas?
La próxima semana el juez, vamos a discutir si hay a las personas tienen el derecho para salir permanente. Si hay un riesgo que hay un criminal o algo así, esas personas no pueden salir de la detención. Pero si no hay un nivel de riesgo, esas personas pueden salir.
¿Qué impacto tiene esto? ¿Qué significa toda esta decisión del juez?
Bueno, esta decisión del juez tiene es muy importante para toda la gente que está en detención en los 5 estados, cerca de la área de Chicago, porque hay una manera que ellos pueden salir de detención. Y también tenemos casos en California, DC y Colorado de nuestra organización de ACLU, y tienen los mismos causas de acciones. Y ojalá que los abogados de ACLU en California, Colorado y los otros estados pueden luchar como nosotros.
Cuéntanos sobre las personas que exigen que sean liberados inmediatamente. ¿Cuántas son? ¿12 personas?
13.
Esos se ordenó que sean liberados inmediatamente.
Exacto.
A partir de hoy.
Exacto. El juez Cummings ordenó que 13 personas pueden salir inmediatamente de la detención de ICE.
Y el próximo miércoles es cuando les están dando el plazo para que tengan la lista de el resto de las personas detenidas por CBP.
Exacto, sí.
¿Qué significa esta orden, esta disposición del juez para personas que aún están en su país y que ya firmaron esa orden voluntaria para salir?
Bueno, si ellos están en los Estados Unidos hoy, el juez puede ordenar que ellos pueden salir de detención. ¿Okay? Si ellos están afuera de los Estados Unidos ahora, no hay un remedio, desgraciadamente, según de nuestro caso. De nada.
Thank you.